call on Mr. MacKenzie from Pennsylvania for 5 minutes of questioning.
Thank you, Mr. Chairman, and want to thank all of our testifiers here today. It's an important conversation that we're having about EBSA and the ability of a government agency to help in the marketplace where individuals are getting their health insurance all across the country, making sure that the benefits they are owed are being paid to them when necessary, but at the same time also making sure that there is transparency and oversight going on at this agency to make sure that they are conducting themselves in a proper fashion. So pretty concerning, some of the testimony that we're hearing today. And my first question is going to be for Mr. Golumbic. Regarding EBSA and the secrecy of the information that was being shared with plaintiffs' attorneys. Obviously, confidentiality was breached there. And what does this do to the willingness of different stakeholders to actually cooperate and engage with the DOL? If they have this concern as a defendant or a potential defendant, why would they even come forward and cooperate or engage with DOL, ultimately in the furtherance of benefits for the individuals? But why would they participate in something like that if they're afraid their confidentiality might be breached?
Yeah, thank you. That's a great question, Representative MacKenzie. And just to put a finer point on it, in the matter that I was involved in that I testified to today, my client, in response to requests for information from the government, designated documents as exempt under FOIA, meaning they deserved confidentiality designations. And to the extent the government was going to furnish it to any outside third party, they needed to give notice to my client. So we had an opportunity to object to it, given the confidential nature of the information. That didn't happen. So I think what we're finding as a consequence, in light of this disclosure that these common interest agreements exist, I'm finding that with my clients who are involved in active Department of Labor investigations, they're quite reluctant to turn over information because they're worried about the government maintaining the confidentiality of it, even if we designate it as exempt under FOIA. And the Department of Labor historically has been reluctant to enter into normal, routine confidentiality agreements, ensuring the safeguarding of information. So it's a quandary, and we have active clients who feel like they're between a rock and a hard place, trying to respond, responsibly in responding to government subpoenas and requests for information.
Yeah, I think it could have a chilling effect on the willingness of participants to participate and engage with DOL, and again, ultimately that would be a problem for the whole system. I would also ask this, are you aware or do you know if this practice is still occurring at DOL with maybe career employees there?
I don't know the current state of the practice at the government. I would, though, add a note in response to other testimony today. What we are aware of are several instances of those type of agreements by the government and class action firms being reduced to writing. But I'm sure and the Office of Inspector General may get to the bottom of this, countless examples of the government picking up the phone and contacting plaintiff's counsel, talking about legal strategy, talking about underlying case, supplying information that doesn't necessarily have to be reduced to writing in a formal common interest agreement.
As somebody who's not an attorney, I'll ask your legal opinion on this, and just an opinion, but could this affect the outcomes of previous decisions that were rendered? If somebody entered into an agreement where they were not made aware of a confidential side deal with DOL and a plaintiff, could that be revisited?
I don't know. That's pretty speculative. I do know, just in terms of matters we're involved in and matters I know that other lawyers in this industry are involved in, they are taking a closer look in active lawsuits to see if there is a connection between the government and the plaintiff's firm and seeking discovery to find out if any such agreements have existed.
Thank you, and just with the remaining time that I have, Mr. Banducci, can you elaborate on your statement about providing suggestions for EBSA and what they should do with the limited resources they may have and how they could conduct themselves more efficiently?
Thanks very much for the question. Chairman Allen, I see I've got 8 seconds, so I'll try to be quick. It really starts with the foundational premise. Large employers, in particular, are mostly doing the right thing. They are providing benefits to tens of millions of workers and their families, and EBSA ought to begin with that premise and that understanding.
Thank you, and I agree. That should be the premise and understanding, and I think we can both do that and make sure confidentiality is protected as well. Thank you.
The gentleman